The shares in a company are like properties and they can be managed as such. We're discussing sections 175 to sections 202, and like we've said in the past few days, we cannot be going into all of these sessions like we did in the first, I think, 2-3 days. We'll just be discussing it briefly, and if it interests you, which I believe it should, then you should pick up CAMA. This is an encouragement for you to pick up CAMA and read it yourself and understand it yourself, especially if you're on this journey because you're going to be writing an exam soon, or because you just want to know the law for yourself. Let's move quickly into sections 175 to sections 202. And sections 175 is talking about transfer of shares. Like we said, shares are like properties and can be managed as such. So a share can basically be transferred by an instrument of transfer, and except as expressly provided in the articles that I'm reading, sections 175, transfer of shares shall be without restrictions, and instruments of transfers shall include electronic instruments or transfer. Entry in register of transfers, sections 176 provides for that. So on the application, sections 176 now, on the application of the transferor of any share or interest in a company, the company shall enter in its register of members the name of the transferee in the same conditions as if the application for the entry were made by the transferee. We already said that before, and if, like we just said, if the name of the transferee is not entered into the register of members, the transferor would continue to be recognized as the owner of the shares, as the member of the company, until such transfer has been effected. Interestingly, in sections 176 sub 3 says the company may refuse to register the transfer of a share not being a fully paid share to a person of whom they do not approve, and may also refuse to register the transfer of a share on which the company has a lien. We move on to the notice of refusal. So if a company actually refuses to register any share, it shall within 2 months after the date on which the transfer was lodged with it, send notice of refusal to the transferee. Of transfer by personal representative. So where a personal representative makes a transfer, it will be recognized as if it was that person who made the transfer. We move to the next, which is transmission of shares, and I would love to state that there's a difference between transfer of shares and transmission of shares, and it's very important for you to note these differences. But in the transmission of shares, it's in the case of death of a member, so the survivor or survivors where it's a joint shareholder, or the legal representative of the deceased where he was the sole holder, is the only person recognized by the company as having any title to his interest in the shares. So you notice the difference between transfer and transmission of shares. Well, the transfer of shares is basically done by the person themselves. It's voluntarily, right? This person decides, I want to transfer my shares. Transmission of shares is not voluntary. It's by by effect of law, by reason of the death of that particular shareholder. We'd also like to state that the company also can exercise a right to decline or suspend the registration, as they would have in the transfer of shares. Move to the next, which is the instrument of transfer. So instrument of transfer, where a person wishes to transfer his shares, it shall be done by the instrument of transfer. This instrument shall be delivered to the company with a request that the instrument of transfer be recognized and registered, and the instrument of transfer shall include certificates issued in electronic form. So one thing that I noticed, which is something that we've had a reason to argue one time, on behalf of a client, is that the CAC did not state any timeline for you to inform the CAC of such transfer. So what had happened was that there was a transfer of share at a particular date, and at a later time the CAC was notified of this transfer, and the company was slammed with a penalty for late filing. And then we argued, how can they be late filing if there is no prescribed timeline as to notifying the CAC? So it's very important for you, see why you should read your CAMA and know your CAMA. Okay, so we move to the next, which is the certificate lodged, where Where a company has recognized an instrument of transfer, it would do that by endorsing on it the words certificate lodged. So once you do that, it's prima facie that the share instrument of transfer has been recognized and registered. So the next is transaction by company in respect of its own shares. Sections 182 talk about redemption of redeemable preference shares. So the provisions of this section apply with respect to the redemption by the company of any redeemable preference share issued by it under sections 147. It's very important to note that once the 147 actually talks about irredeemable shares, where it says that no company limited by shares after the commencement of this act shall issue a preference share which are irredeemable. So all preference shares shall actually be redeemable, and all of the modalities as to redemption of those shares are contained here in sections 182. So the next is 183, which talks about provision of financial assistance by company for acquisition of its shares. That's a whole lot, and it's all contained there. We wouldn't be able to go into that because of time. The next is 184, acquisition by a company of its own shares. So a company can actually acquire its own shares subject to the provisions of sections 184 outlined here, that a limited company may purchase its shares, including redeemable shares, provided that a company may only purchase its shares if so permitted by its articles, and the shareholders shall, by special resolution, approve the acquisition by the company of the shares that it intends to purchase. And all of those conversations as to the acquisition of a company's own shares are contained in sections 184. I'll just like to add that when a company actually, so a shares that was previously issued and a company then buys it and owns it, that share is called treasury shares. So whenever you see treasury shares, it's talking about shares that are owned by the company itself. Section 185 talks about the payments for share buyback. That's for the payments for these treasury shares. So when a company buys back its shares, payments for share buyback shall be made from the distributable profits of the company. So that's the only way that the company can actually pay for those treasury shares. The people who the company can actually buy its shares back from are contained in sections 186, and I think we'll just go about it. It's very short. So that's from the existing shareholders or security holders on a proportionate basis, from the existing shareholders in a manner permitted pursuant to a scheme of arrangement sanctioned by the court, from the open market, and by purchasing the securities issued to employees of the company pursuant to a scheme of stock option or other similar scheme. There's also a limit to the number of shares that a company can actually acquire, and that is that it should not be more than 50% of the nominal issued share capital of any class. It's also very important to add that sections 187 sub 3 states that notwithstanding anything contained in sections 142, that's in respect to preemptive rights, a company shall not exercise any rights in respect of the treasury shares. Sections 193 actually talks about statements that can be included in this debenture, and it talks about the principal amount, of course, the rate at which it was given, the rate of interest, the repayment date, if it's a convertible shares, when and in what condition it can be converted, and all of that, right? And effect of the statement of debenture is that it's prima facie evidence of the title to the debenture of the person named therein as a registered holder and of the amount secured thereby. So types of debenture, there are types of debenture all contained in sections 196 to I think sections 199. So we'll just go over them real quick. Perpetual debenture, of course, there's no fixed date for repayment of the principal. There is a convertible. You can read all of these things in details, all contained here in sections 196 to 199. The next is convertible debenture, which is it can be converted to shares after a specific period or after certain conditions are met. The next is the secured or unsecured. Very simple. It's backed by specific assets or not if it's unsecured. The next is redeemable debentures, which is repaid at a fixed date or after a specific period, right? Then we move on to the right power to okay. The next is let's skip 200 to
201 and just states that 201 and 202 just outlines the right of debenture holders. It's all contained there. One of which is that the debenture holder may sue the company which issued the debenture he holds for payment of any amount payable to him in respect of the debentures. He can sue for breach of duties, which the trustee of the debenture actually owes him, and such other rights as outlined in sections 201. And then we move to 202, which talks about the meeting of debenture holders. So debenture holders may convene a general meeting of the debenture holders, and all of these interesting facts are all contained right here in sections 202. And that's all we can take for today. We're counting down to day 30, and I know that we're going to get there by God's grace. So if you're yet to start picking up your camera, this is your sign. I'll see you